Good morning, Mr. Egan. I understand that you have 7.5 minutes.
Correct, Your Honor. May it please the Court, John Egan for the Fall River Housing Authority. Broadly speaking, there are two issues in this case. The first is prostitution a lawful basis for terminating participation in the federal Section 8 program, especially where the offending conduct occurs in the subsidized residence? And second, did Ms. Costa receive a fair termination hearing that comported with due process? I'm prepared to answer whatever questions the Court has with regard to either issue, but by agreement before the hearing with my brother from the Attorney General's office, it was agreed that I would address the first issue, at least at the beginning of my argument. The Fall River Housing Authority terminated Gail Costa's participation in the Section 8 program after she was arrested and charged with engaging in prostitution in her home, the same premises that were being subsidized by her federal Section 8 housing voucher. She subsequently pled guilty to those charges. This Court has, just within the past year, addressed in a slightly different context the Section 8 program in the Carter versus Lynn Housing Authority case, so I won't belabor the fundamentals of that program.
How does Ms. Costa's admittedly criminal act, she's pled guilty to it, but I wonder how, on the facts of this case, that threatens the health or safety or right to peaceful enjoyment of other residents? As I understand the facts, she lives in a single-family house at the end of a dead-end street or something, and her neighbors have never said that she was any bother. In fact, they have affidavits to the contrary.
Correct, Your
So
Honor.
how does she, my question stands.
Your Honor, I think by definition.
No, not by definition. I'm wondering how she, if you would tell me how she threatens the health or safety or right to peaceful enjoyment of the other residents.
Because, Your Honor, the crime of prostitution, especially in a residential neighborhood like this, is an inherently socially corrosive activity.
You want to answer my question because the other tenants, the other people who live there, say that she's not a bother.
That's correct.
So it isn't inherent. I mean, if somebody comes in somebody's house and pays for sex once a day, how's that any different from somebody's boyfriend coming there once a day?
Because the former is illegal and the second is not.
Okay, but how does it, in effect, from what I'm asked, the two scenarios that I posited, how does that threaten the health or safety or the right to peaceful enjoyment of the other people who live nearby?
Your Honor, the appeals court suggested the answer to that question. They did not have to explicitly reach that question because of the way that the case was resolved in the housing court. But in footnote 8 of the appeals court opinion, that court suggested very strongly that irrespective of whether a couple of neighbors considered her conduct to be sufficiently quiet and low profile not to have bothered them, the crime of prostitution, especially in the context in which it was committed in this case, in, as you say, a quiet residential neighborhood, is visibly asocial conduct.
But the statute, the regulations aren't written that way.
No, the statute says criminal conduct that threatens the safety, health, or right to peaceful enjoyment of those in the neighborhood. And what the appeals court said is that, and it cited two earlier cases from this court, the Melendez case and the Bryant case. What the court said is that it should not be necessary for the actual threat to materialize in order for those regulations to have some effect. And in effect, that's what the housing court's opinion would result in. A person like Ms. Costa engaged in the activity that she was engaged in would be immune from enforcement of the regulations under this program, so long as she continued to keep her peace with her neighbors. The administration of the program.
But isn't that what the regulation is designed at?
I don't believe so, no. The regulation, I think, is designed to ensure that those who are benefiting from this federal rent subsidy should not be engaged in criminal conduct that in certainly most circumstances is uniformly considered to be the kind of socially corrosive, socially destructive effect that warrants it being illegal in the first instance.
Mr. Egan, here, I think what really the gist of Justice Cowen's question is there's certain criminal activity which is specifically identified, drug-related, violent criminal activity. And then there's this other catch-all phrase. It doesn't say, it's not any criminal activity. It's not all criminal activity. The statement that you just made, I mean, when the legislature declares that certain things constitute crimes, in a way, the legislature is saying that these are inherently socially corrosive activities. Given that the regulation, we didn't draft the regulation, presumably permits the conduct, the tenants to engage in certain criminal activities and not have their Section 8 benefits terminated.
That's fair enough.
What is it about prostitution? What is in this record about prostitution that says there's something about prostitution, or the prostitution in this case, that threatens the health, safety, or right to peaceful enjoyment?
Nothing.
I mean, it's very hard for me to see how it threatens the health. Correct?
That's fair to say.
Okay. So we're left with safety.
Safety and the right to peaceful enjoyment.
And right to peaceful enjoyment. And, you know, one could, I suppose, say anybody who engages in any crime means that they might do anything to one's neighbor, but that's not the way the regulation is written.
No, but certain crimes are inherently.
But you keep saying that. But how do I know?
You don't know from this record as to whether this person in this residence, in this neighborhood, actually threatened the safety or the right of peaceful enjoyment of these neighbors. And my point is that a housing authority faced with this conduct from somebody participating in this federal subsidy program should not be required to demonstrate that this particular...
No, but was there evidence that in general when prostitution is conducted in a neighborhood, the neighborhood begins to deteriorate? Is there, I mean...
I think that's been fairly well established enough over the course of time so that...
Where?
In our society, Your Honor.
I take it in this case, it's obviously, she's not just been charged with prostitution. She's been charged with running a house of prostitution in the very location in which she is a subsidized tenant.
Which I think is a critical component of this case. If Ms. Costa had been arrested on the streets of Fall River, this would be a different case. The fact is that she's running an operation out of her home, subsidized by federal money, and I think we know enough about prostitution at this point in time that someone engaged in that activity in their home, in the neighborhood, at least threatens.
Can you point to any study, any evidence?
There is no evidence and no study in this record. I'll concede that point, Your Honor. The point I think that the appeals court made is that it should not be necessary for a public housing authority attempting to administer this program to have to put forth that kind of order of proof in order to justify termination under the regulations. And that is the position that HUD has taken in this case in their amicus brief.
The difficulty with that is that presumably whatever the crime is, the housing authority should just say, well, it's inherent, and I think we know enough about this. You know, it could be, let's assume that the tenant is counterfeiting money. Well, it's just inherently socially corrosive, and I think we know enough about counterfeiting money. You know, I mean, I hope you understand the difficulty.
Well, counterfeiting money out of the house.
Yeah, that's
running a counterfeiting operation out of the house.
Well, that's what I'm talking about.
But even if, Your Honor, that was the case, if Ms. Costa were counterfeiting money out of that house, I think, frankly, a housing authority would have a much more difficult argument to make that that activity is an inherent threat to the safety or the health or the right to peaceful enjoyment
Say
of
that,
the
but
neighbors.
the regulation isn't written that way. The regulation could easily be written if the criminal activity is certain crimes, drug-related. We don't care if it's taking place in the apartment. You're out. Other crimes, if they're taking place in the apartment, all crimes, you're out. If they're not taking place within the apartment, in other words, if you're a counterfeiter, but the counterfeiting was taking place in some business district, down the street, that's different. In any event, I understand your argument, Mr. Egan. Thank you.
Thank you.
Mr. Salinger?
Good morning. Ken Salinger for the Commonwealth. I'd like to offer two additional reasons why prostitution falls within the scope of the regulation regarding other criminal activity. First, HUD, the author of the regulation, says so in its amicus brief in footnote 2. And as a matter of federal law, their interpretation must be given controlling weight. Secondly, the legislature in General Laws Chapter 139, Section 4, has deemed that every building used for prostitution shall be deemed a nuisance. This court, as far back as 1856 in Commonwealth v. Kimball, 73 Mass at 331, has found that under that statute, the Commonwealth need not prove any particular annoyance to the public or the neighborhood in order to show that prostitution is a nuisance. And similarly, HUD's reasonable interpretation of its regulation controls here.
Is that argued in any of the briefs?
The point about Chapter 139, Section 4 was argued. The point about HUD's interpretation was argued by HUD in its amicus brief, and the point about the controlling weight that interpretation must be given was argued by HUD and by us in our reply brief. If I may turn to the central due process issue, just as incarcerating someone in a civil proceeding based solely on reliable hearsay does not violate due process, so here, terminating this housing subsidy based on a reliable police report of prostitution did not violate due process. We've shown in our reply brief, especially pages 2 to 7, the long line of cases holding that relying solely on reliable hearsay does not violate due process.
Is this case essentially decided by Covell?
It's decided by Covell, it's decided by Durling, it's decided by Murphy.
Well, Durling is a little different because Durling involved probation revocation.
Well,
And
it's
different because there's been a conviction and there can be distinguishing factors. But Covell, it seems to me, is closer to this case.
And Murphy, Your Honor, also involving incarceration. Those were the confidential prisoner informants. It was only their reliable hearsay deemed reliable because of the factual specificity. That was the basis for revoking the good time credits at the DOC facility. Well, if that kind of reliable hearsay is sufficient to incarcerate someone, it's certainly efficient to take away the non-fundamental interest. Remember, in Spence, this court distinguished one's interest in a public housing subsidy from the liberty interest in avoiding incarceration, and made clear.
Then the only question would be whether this is reliable hearsay.
That's right, Your Honor, and we submit that it is for several reasons. First, like in Durling, we submit this police report has, in the court's words, inherent reliability, both because it was a report that related primary facts personally observed by the detective, and whether signed or not, it's a crime for the detective to submit a false report under Chapter 268, Section 6A of the General Laws. So as in Durling, for those two reasons, it is inherently reliable. Furthermore, Ms. Costa, as she concedes in her complaint, corroborated to the Housing Authority at the hearing some of the key facts. She acknowledged that an appointment was made, that she was agreeing to participate in what she described as fantasy play in exchange for money, and she agreed that her friend was there and offering as part of this get-together to engage in sex with the detective. The only thing she denied was whether she personally was prepared to engage in prostitution, and certainly the Housing Authority could weigh her credibility in deciding whether to accept her version of the events.
Did she admit to sufficient facts?
My understanding, Your Honor, is in the criminal proceeding she actually pled guilty.
Pled guilty.
to both charges. The Housing Authority was not aware of that, but she did plead guilty. It's also worth noting, Your Honors, that although Ms. Costa was represented by counsel before the Housing Authority, she did not object to this police report coming in on reliability grounds or otherwise, and she concedes that at page 26 of her brief. And
Yes, but her argument is that it came in for all purposes, but nevertheless, it's not sufficient.
That's right,
what her
but in
argument
response
is.
to your question, Your Honor, about is this report reliable, I think it is relevant that although she could have tried to keep it out on the ground that it was not sufficiently reliable to even be admitted, she made no attempt to do so. But if the police report in Durling is sufficiently reliable to put somebody in jail, then this police report is sufficiently reliable to terminate the housing subsidy. We're certainly not arguing.
But wasn't Durling, correct me if I'm wrong, but wasn't Durling the case that had 2 police reports? Is that a different one?
I think that's correct.
I believe there were
In Durling,
2.
there were 2 police reports, and they were interlocking, so they corroborated each other, and they were 2 officers from 2 different departments. So
Right, and here
it's a little different.
Here we have one police report that in material respects were corroborated by Ms. Costa herself, at least as good a corroboration as the 2 reports in Durling. The other of the 3 Matthews v. Eldridge factors, of course, is the strength of the government's interest. Ms. Costa argues that, well, there's a much stronger government interest in a criminal case, in locking up a dangerous criminal. To some extent, that's true, but very similar interests are at stake here. Although there's not the punitive concern, because this is not a criminal matter, this regulation is indeed about protecting and guarding against threats to the health, safety, and right of peaceful enjoyment of neighbors. The amici housing authorities and agencies have explained how hard it would be for them to administer the Section 8 program if they were unable to act based on reliable police reports and other reliable hearsay information gathered from landlords, from neighbors, from employers of tenants. These are agencies that do not have subpoena power, and if the essentially per se rule against reliable hearsay that the Housing Court adopted became the rule of law in Massachusetts, these agencies could not go forward with proceedings in many instances, and there would be very serious questions about whether in probation, revocation proceedings, and other civil proceedings where this court has previously held that reliable hearsay can be the sole basis for acting, whether those lines of decisions would be called into question. I should note, as we point out in our reply brief at pages 8 to 10, it is simply not true that due process requires that there be a right to subpoena in the witness. The Perales case, Richardson versus Perales, the Supreme Court case, what happened there is that because there was a right to subpoena the witness and it was not exercised, in essence the Supreme Court said any objection was waived. The failure to subpoena the witness precluded the individual from complaining that the SSDI benefits were terminated on the basis of hearsay. That's at 402 U.S. at 405. But we cite a number of cases explicitly holding that nothing in the due process clause requires a subpoena right, and that's certainly consistent with this court's holding in Murphy. Again, those confidential prisoner informants, by the nature of them being confidential, is why there was no opportunity to make any effort to get them to testify at all. And so it is our submission, Your Honors, that the Housing Court erred in adopting a new per se rule that would bar the use and reliance on reliable hearsay, that Detective Huard's report, as we've discussed, had inherent reliability, and that therefore the Housing Court's order should be reversed.
Thank you, Mr. Salinger.
Thank you.
Ms. Lohr?
May it please the Court, Deborah Rower for the appellate, Gail Costa. It is our position that the Housing Court and the Appeals Court were correct in all of the due process rulings, and that it is the interveners here who seek to expand accepted law on the subject of hearsay.
Well, how can you distinguish this case from Covell?
In Covell, the hearsay consisted of transcripts from a prior case in which there had been active cross-examination. Very different. I think the case that's perhaps closest to where this court has gone, where the interveners would want to take it, is Durling. But as Your Honor noted, there were 2 reports. There was corroboration in the
But Mrs. Allen
consistency.
just said it was corroborated here by the defendant's own admission.
I disagree with that. First of all, the Housing Authority decision says it's based on the police report. There's no reference to any reliance on anything that Ms. Costa said at the hearing. Frankly, the idea that because she admitted that her version of what happened agreed in some particulars with the undercover officer's report, that constitutes corroboration of those facts that she didn't agree with, that she actively disputed, I just don't get that argument. To me, it's a non sequitur.
And then what do we do with her plea? Her plea came after the hearing, but
Yes.
before the final decision.
Her plea came after the hearing, so in terms of the due process considerations at the hearing, it doesn't have anything to say at all. As the appeals court noted, at a subsequent trial, it could be introduced as evidence, not dispositive, not a judicial admission, but an evidentiary admission, and she would have the opportunity to explain why she pleaded to it, which is actually included in her affidavit in support of her preliminary injunction, which is in the record in this case. But she would have the opportunity to elaborate on that, and a future fact finder could accept that or reject it. We are, of course, bound by the fact that she did make the plea. I would say one thing about that. Obviously, the charge of offering to engage in sex for a fee, there were factual disputes about what happened, and if she had not pleaded to that, she might have been convicted, she might have been acquitted. The charge of running a house of ill repute, the factual basis for that was simply the fact that there was another woman in her house on the day in question.
Offering to have sex for money.
Yes, which is something very different from what I would call the kind of tabloid version of events that you get from the newspaper article. What actually, the record here, the police report.
Can't we infer that this was a regular pattern?
No, we absolutely cannot.
But
This was an internet business. The customers were
yeah.
The only source of that accusation was the newspaper report. That's not in the police report. It's nowhere else. That's very important.
She didn't admit that she got her customers over the internet.
She did not admit that she was running a business.
She got her customers over the internet.
She admitted that she had some kind of an internet presence for being a dominatrix. Yes, not for engaging in prostitution.
I'm sorry, would you say that again?
I believe she admitted. I'm couldn't say where I've seen this, but I think she admitted that she engaged in fantasy play as a dominatrix, and that I think we can infer that she had some kind of a presence on the internet.
And she solicited customers over the internet. She had a website or something. I mean, isn't this?
I don't believe there is a reference to a website. That's open. There was some internet presence. Yes, there was. The interveners say that we are claiming a right to subpoena. We are not claiming a right to subpoena. What we are saying is that in all of the due process analysis that the courts have gone through, the absence of a right to subpoena is a very important fact in determining whether the government has to provide witnesses who can be cross-examined. And this appears, among other places, in the preamble to HUD's discussion of the regulation in 1990 when they adopted it. The best place to find that is in the addendum to the brief of the tenant amici at addendum page 60. I mention this for a couple of reasons. One of them is I do want to address the argument that HUD's interpretation of its regulations, which comes here by way of amicus brief, is, as my brother has asserted, dispositive, conclusive, fatal to my case. This is not, I think, a case in which the agency's interpretation of its regulations offered in an amicus brief is entitled to that degree of deference. The case law is clear that in determining whether the position in an amicus brief represents an agency's full and fair consideration of the issues or just an ad hoc, post hoc litigating position depends on a number of factors, and one very important fact is the consistency with which the agency has or has not taken that position. It's very important to look at, for example, what the agency says at the time that it promulgated its regulations. And here, both with respect to the hearsay regulation and both with respect to the substantive regulation, the regulation about grounds for terminating or what happens if a tenant commits a non-drug-related, non-violent crime. In both of those cases, as I have argued in my brief and as the tenant amici have argued in their brief, the regulation in the preambles to the applicable regulations, HUD had some colloquies. It accepted comments from various interests, and it came down on the side of this kind of crime is to be dealt with by the landlord. The landlord has the right to terminate the tenancy, but not the housing authority to terminate the benefit. And with respect to hearsay, HUD clearly made a nexus, a connection between the fact that it couldn't offer the tenant the right to subpoena, used that to buttress the requirement in its regulations that the tenant have the right to cross-examine. That's completely inconsistent with the position that HUD is taking in its amicus brief, that it's entirely up to the housing authority to decide whether it wants to have any witnesses, and if it chooses not to have any live witnesses and there's no right to cross-examine and there's no right to subpoena, well, that's just too bad. What's disturbing about this is that I think if the intervener's position in this case is adopted, I just can't see why a housing authority would ever bring in a live witness in any proceeding, or perhaps.
Well, this is just not any witness. This is an undercover police officer who has given a detailed account of precisely what he did and what your client did during an undercover operation. We're not talking about. I mean, that's pretty reliable stuff. That's not your ordinary run-of-the-mill hearsay.
It can be reliable, but again, let's...
About which she was arrested and criminal complaints issued, I mean, that's a little different than any run-of-the-mill hearsay.
It is different, but are we going to make a separate rule for police officers? Are we going to
the question is whether it's sufficiently reliable and therefore both admissible and sufficient.
Fine, but to say that it's reliable because it's a police officer, are we going to say that police officers are immune from errors of perception, errors of bias, errors of jumping to conclusions, and are we going to say that particularly I can't not make the point that the police officer engaged in deception to get into Ms. Costa's home in the first place. Deception was the essence of the operation here. So if we're going to have a separate rule to say a police officer is always reliable because it's a police officer, I think that's problematic.
That isn't the rule. I mean, first of all, if you look at Durling, don't the factors that apply in Durling to excuse the presence of the police apply in spades here? I mean, they said things like the police can't come into every district court hearing on probation revocation or whatever it was. And so they can't be coming into every housing authority proceeding and then paid overtime and on and on and on. But so I'm just saying that the same factors would apply in Durling. In addition, of course we can't say that every police officer's report is reliable and there are problems of perception and things like that apply, and even intentional deception. But when you've got corroboration, such as Durling requires, and exists here, isn't that sufficient? Again,
I would take issue with the characterization that there's any corroboration here. I think what you have here is the essence of when cross-examination is important. What you've got is a direct contradiction between two people who were two of the only three people in the room, neither of whom is a disinterested witness. Again, different from Durling. In Durling, the two officers happened upon the driving. They just happened to be there. This officer didn't just happen to be there. We can go with Durling. I mean, I've attempted to argue in my brief how Durling is distinguishable. As far as the unavailability of police officers to testify, Housing Authority has police officers on detail working in its developments. I don't know for a fact whether it's true that a police officer would have been unavailable in this situation, but I do think that in a situation where the Housing Authority bears the burden of proof and has complete discretion in the timing of scheduling a termination hearing, that it, as I say, takes a certain amount of audacity to say we're going to excuse the ability of the witness because it would be difficult for the Housing Authority to produce it. They can wait until the criminal matter is disposed of. In many cases,
Well, that's not going to help you here, really.
I'm sorry?
That's not going to help you here. I mean, even though at the hearing there was no evidence that the criminal matter had been disposed of, as a fact matter before the decision issued, the criminal matter had been disposed of.
No.
She pled guilty.
No. When you say the timing was, she pleaded guilty after the hearing.
Right, but before the decision.
No. The decision. Well, no.
Oh, before the written decision. I guess there was
The
an
same
announcement.
day as the written decision.
All right.
The same day as
But
the
the point
date
is,
on the written
how's
decision.
that going to help you in this case?
How is?
I mean, yeah, the authority could have waited until after the criminal disposition.
Yes.
But in this case, the criminal disposition was not in her favor.
Right, and there would not be an issue here of hearsay and the proper limits of hearsay if they had waited and just come in and brought in the criminal disposition. I mean, we wouldn't
So
be
that would
here.
be the end of the story if there's a criminal disposition.
It wouldn't be the end of the story in terms of being dispositive of her housing case, but it would be the end of the story as to the issue that brings us all here today. Yes.
The conduct, the underlying conduct, it would be dispositive of the underlying conduct.
The need for or the degree to which the Housing Authority could base a decision exclusively on the police report would not be presented in the same way.
All right.
I also know that the police report in this case was unsigned, and the only date that appears on it is actually not really close to the date of the arrest. It's 2 weeks later, so we don't know what we are dealing with here in terms of the police report.
Again, there were no challenges to the police report at the hearing.
No, and
She was represented by counsel, so we're not talking about a pro se litigant.
That's true, but again, look at the nature of the hearing, and I just want to come down to this. It's not that hard to run a proper administrative hearing, but everything about the manner in which this Housing Authority has proceeded, it just makes it impossible for the tenant to get the kind of hearing that the regulations intend and that the courts intend. There was no procedure in this hearing for evidence to be offered, ruled on, admitted, or excluded, as is set forth in Ms. Costa's affidavit in support of the preliminary injunction. The procedure was she went into the hearing. The 5 lay members of the hearing panel had packets of stuff on their desk, and that included the police report. It included the newspaper article. So to talk about waiver or what you could have done to get that excluded, it really was not part of the procedures, and it is not the tenant's responsibility to set up fair procedures. It's the Housing Authority's responsibility to provide fair and lawful procedures before
I take it
terminating.
this wasn't recorded or anything. There was no tape recording.
There was no tape recorder that I know of.
How do you, what do you say with respect to the appeals court reading of the regulations?
Believe that the housing court was correct on that. It is the regulations are certainly not a model of clarity, but particularly, with respect to the argument that they were amended in 2001 to give broader scope to criminal to the Housing Authority to terminate for criminal activity. What I would focus on is that the amendment took place in the wide-ranging family obligations section, but there was no amendment to section 982.553, and I'm reading here from page 612 of the CFR in the addendum to my brief. It's 982.553B2, which now reads and has read since 2001 or at least, the PHA must establish standards that allow the PHA to terminate assistance under the program for a family if the PHA determines that any household member has violated the family's obligation under Section 982.551 not to engage in violent criminal activity. Well, if there was an intention to amend these rules to enlarge the scope of activity that was subject to termination, that was the place to put it. It certainly would have been easy to say obligations under 982.551 not to engage in violent criminal activity or other criminal activity that threatens the health, safety, or peaceful enjoyment.
They added it to the permissive prohibitions in terms of denying admission.
Yes, and the admission rules and the termination rules have always been different. And it may not make sense, but they've always been different.
Thank you, Ms. Liu.
Thank you.
We'll take a short break.